The next speaker is the Honorable Minister of Justice and Correctional Services.
The Deputy President of the Republic of South Africa, honorable members, I begin by expressing my sincere gratitude to Honorable Horn for bringing up today's important discussion. I'm happy that mostly honorable members understand the nature and the complexity of extradition. Most honorable members also stated that extradition relates to cooperation between requesting states and the requested state. It can also be polycentric in nature and it straddles between law and politics. And Honorable Lamola has already stated that extradition necessitates a significant degree of cooperation between the requested state and the foreign states. All these are issues that this House agrees upon. And any other thing that the honorable members from the oppositions have said is cheap political scoring, because they understand the nature and the complexity of this thing. They are just saying it because they want to blind South Africans, not to see the reality of what the South African government has done in all its efforts with regards to complying with the extradition treaty between South Africa and the United Arab Emirates. The legal system of different countries vary, with some employing common law and others using civil law systems. Countries with civil law systems are generally less likely to extradite their citizens. Any other thing is in relation to our work that we have done with the United Arab Emirates. The United Arab Emirates implements civil and Sharia laws in the legal framework. The legal framework in the UAE is unique amalgamation of Islamic Sharia principles and civil laws from Egypt and France. Only family members can access the court system in the UAE. Is daydreaming by Honorable Horn that I was aware. No South African diplomat or anyone was aware of the court case when it said, because unlike our courts, it's not an open court system. It happened and we were informed on the date that we informed the South Africans, and we wasted no time. We informed South Africans on real time when we received the note verbal on the eve of a Good Friday. The 3 months that were informed in 3 months, and when it happened, it is just political scoring. There is no foolish administrative or legal mistakes from the South African government. Neither did we bungle this extradition request. It is important that we note and expose what Article 44 and subsection 17 of the United Conventions Against Corruption, it provides as follows, that before refusing extradition, the requested state party shall, where appropriate, consult with the requested state party to provide it with ample opportunity to present its opinions and provide information relevant to its allegations. A request for extradition cannot be denied on the basis of any mere technicality. This is not Lamola speaking. It's the United Nations Conventions Against Corruption. Because the United Nations understand that countries try to hide behind the technicality to deny an extradition request. Before we submitted the extradition request, there was cooperation and engagement between the two central authorities, including the prosecuting authorities of both countries. And the UAE authorities confirmed and certified that the documents that were submitted in the UAE are in compliance with the extradition agreement. The agreement was therefore, and the processes and documents was therefore submitted by the prosecuting authority of the UAE in the courts in the UAE on behalf of the South African government. Where is the incompetency of the South African government? If an extradition request is brought to South Africa, as we do and help other countries, is the prosecuting authority of South Africa that prosecutes and deals with the matter here in South Africa. If there is a paper or a document that is missing, as honorable members are saying that there was a defective cancelled warrant of arrest, the prosecuting authority here in South Africa is duty bound to say to the requesting state, there is this document that is missing, we are unable to process your matter, please bring that document. And this is in line with the convention. You don't shock the requested state with the outcome of the court. So we deal with extraditions and mutual legal assistance on a day-to-day basis. It's our daily bread. This is the process we follow every day. Where papers are missing, Where there is something that is not there, we request the requested state in line with the convention and in line with the extradition agreement in between the two countries. So this is the process that the South African government has followed, and we will continue to follow in our engagement with the UAE to protect the integrity of the bilateral agreement that we have between the two countries. All the processes, as I've said, also with regards to the issue of the charge of money laundering that honorable members were speaking about. The Article 5A of the extradition treaty provides that if the courts of the requested party have jurisdiction to prosecute the person for the offense for which extradition is requested, the requested party shall prosecute that offense. The underlining and operative word is shall. The note verbal we received from the UAE did not tell us what the UAE is going to do with the charge of money laundering, despite the fact that the judgment in the UAE has said that they have got competent jurisdiction. So in line with this agreement, it means they are obliged to prosecute on a charge of money laundering. But they've been let loose and released without them being charged, without respecting the content of this bilateral agreement, Article 5. So where is the incompetency of the South African government? We are the ones here, the current administration, that ensure that the bilateral agreement between the UAE and South Africa is entered into, is signed, and is domesticated by this parliament. It's you, honorable members here of the current administration, that domesticated this bilateral treaty that we are debating now. So how can you turn around and say we're not serious? If we're not serious, we will not have domesticated this bilateral treaty. We will not have ensured that this treaty is signed. We will not have followed through. There was no reason. We stand to benefit nothing. But the reality is that the rule of law must be respected by all and sundry. There must be accountability. There must be everyone who's accused must be held accountable in our courts. It's a duty that with the administration of justice, we are prepared to uphold. What have we done with regard to the NPA to help them rebuild, to help the NPA focus? We are on course to rebuild the NPA to be fit for purpose, to fight crime and corruption. The National Prosecuting Authority has filled over 100 senior level vacancies, revived an aspirant prosecutor program. The NPA has achieved high finalization and conviction rates in organized crime cases, with 21% improvement in verdicts in the last financial year. An additional 4 billion rands in punitive reparations has been paid by ABB with regard to ESCOM. 4 billion rands is back, is in the fiscus. We are now going to use it to recapacitate our law enforcement agents. This is work in progress and is visible. You can touch it, it's in the account. We are not giving any other flimsy theory. It's real. You can touch it in our bank account. This progress sends a clear message to those who have benefited from state capture that they cannot evade accountability. We will make sure that the rule of law is upheld in our country. However, we acknowledge that much work still needs to be done to improve our system and to meet public expectations. The level of crime must be matched with the same level of sophistication by the state. It is against this background that the president established the ID to deal with matters emanating from the State Capture Commission of Inquiry. Fundamental reforms are necessary to achieve this, and we are committed to make it necessary changes. In the 6th administration, we have been deliberate about augmenting the capacity of the NPA by approving appointments in terms of Section 38 of the National Prosecuting Authority Act. This as follows a budget allocation of 5 billion rands over the MTSF period, which is a significant resource to build the capacity of the NPA. This also included, in terms of the appointment in terms of Section 38 of the National Prosecuting Authority Act, technical expertise to help with the extradition cases with regards to the Guptas and other international matters and prosecution in the local courts. This is the appointment of senior counsels of various complexities and skills. That is a deliberate action by the South African government to help assist the NPA to do their job without any fear, favor, or prejudice. About 25 external counsels were sourced in this regard to assist in this process. So this is a demonstration. We put our money where our mouth is, as this current administration, and this is a demonstration of commitment to fight against corruption and to ensure accountability. Honorable members, as I have said, extradition can become a protected legal process. In our shows where matters delayed for years due to technical legal challenges. The first case we dealt with post-democracy on extradition was the matter of Haxen versus President in 1994. Haxen took up various issues in relation to the Extradition Act of South Africa. This matter was in our legal system for 6 years. It was only finalized in the Constitutional Court in 2000. Even in recent times, we have also dealt with Kong Heaven case, who was arrested in 2016 and only got officially approved for extradition in 2022. Even then, the Constitutional Court had been called upon to adjudicate this case by way of an appeal. So this shows that extraditions by their nature can be protracted, but at the end of the day, the rule of law prevailed, and we ensure that when the court has decided, we handed over the people, but it was after some time. So we are calling for calm. Was saying, as the government of this country, we will ensure that the Guptas come back to South Africa to account for their sins and for their crime. There will be accountability. It may take time because of the protracted nature of extradition, but it's going to happen. They will one day face justice in the courts of our country. Same with the Bushiri matter. The man and the gentleman called Shipilelo Gama, who have scored significant victory in the courts of Malawi, where he is taking all manner of technical points, legally and otherwise. We have up to so far, we have gained an upper hand. We have won various court cases and decisions in Malawi on the Bushiri matter. And the matter is again now taken on another technical point. And working with the authorities in Malawi, we are continuing to follow through the matter. And we want to appreciate the prosecuting of Malawi. Every time the matter is sitting, for example, they tell us that the matter of Bushiri is going to sit on this day, and we inform the nation that on this date, the court case is going to sit. We are not shocked by a judgment in
Point of
Malawi.
order, Chair.
Every time.
There's a point of order. Honorable Minister. Honorable Minister, can you just take a seat, please? What is the point of order, Honorable Member? Order, honorable members. Order. Order, honorable members. What is the point of order, honorable member?
The point of order, Chair, is that the Honorable Minister is actually misleading the House in that
Order, honorable members.
the Minister is misleading the House, giving the impression that there would have been a valid warrant.
No, honorable member, that's not the point of order. That's a point for debate. So please continue, honorable minister.
But the minister is lying.
Order, honorable members. Order.
No, I won't be surprised when Honorable Mani catch feelings when we debate the Guptas. It's public knowledge. It's public knowledge, so. But there was indeed,
Order, honorable members.
there was indeed a valid warrant of arrest that was issued. Even the cancelled warrant was submitted on the basis of agreement
You are
between the
believing
two
your own
states.
lies.
There was agreement, there was clarity, and it was accepted that all the papers are in order. With regard to the matter of Shipililo Gama, well known as Shepherd Prophet Bushiri, we are also following through. We have scored significant victory, sometimes suffering minor legal challenges, but even there, the rule of law will prevail. He will definitely come back to our country and justice will prevail. Thank you very much.